Good afternoon to our distinguished panelists, guests, and the numerous attendees joining us from all across the world. Welcome to today's webinar on the theme Harnessing Ecocide Law to Combat Environmental Crime in Africa. My name is Nomasango Masiemoyo, and I am the coordinator of the Environmental Lawyers Collective for Africa. I'm deeply honored to be your co-facilitator for this crucial discussion. Joining me in steering this conversation is the able James Gandhi, a renowned expert in environmental, human rights law, as well as policy, and the current Africa High-Level Coordinator of Stop Ecocide International. Today's webinar is hosted by Stop Ecocide Africa together with the Environmental Lawyers Collective for Africa. And these two leaders in environmental advocacy have come together with the shared commitment to facilitate a discussion on the critical ideology of ecocide, with the hopes of creating pathways to greater accountability and promoting transparency in matters of environmental governance. Our focus today is particularly poignant when considering Africa's specific vulnerability to the climate crisis. The continent faces unique challenges exacerbated by climate change, including extreme weather events like floods, recently experienced in Kenya and South Africa this past month, droughts, fires, and other threats to biodiversity. With reports stating that fossil fuel expansion is likely to increase on the continent in the next 6 to 10 years, something must surely be done. It's therefore important to note that amid these challenges lies a great opportunity for innovative solutions that push the needle of environmental justice forward. One potential solution, which seems to be gaining momentum, is the concept of placing accountability and transparency front and center in environmental governance. And this is where the theme of ecocide comes in. Throughout our webinar today, we will explore these themes in depth, examining how initiatives rooted in accountability and transparency can not only mitigate environmental damage, but pave the way for an equitable African society where the well-being of its people and ecology are appropriately placed above all other aspirations. Colleagues, French interpretation is available today. Simply click on the tab that you see right at the bottom of your screen and choose your preferred language settings. Additionally, we also have a Q&A chat box available for you to type any questions to our speakers during their presentations, and there'll be an opportunity sometime during the webinar for them to respond. Thank you once again for joining us. Over to you, James.
Thank you very much, Noma, for that very erudite introduction to this very important meeting that specifically looks at ecocide law in the African context. And what we want to say and discuss today is that ecocide law, or ecocide as a concept, is very new to the global south and to Africa in particular. We've had a lot of success in Latin America, in Europe, and other places in terms of spreading the word about what ecocide is, what ecocide law is about, and what it intends to achieve. The context is that Africa suffers the greatest brunt of pollution from harmful extractive activities, climate change, and the biodiversity loss, because we've got a rich natural heritage of biodiversity in Africa. So it is us who stand to lose the most from harmful environmental activities, harmful activities that affect the environment. What we would like to do is, in addition to adaptation, mitigation, and everything we've tried to do, introduce another level of deterrence through criminal law, through international criminal law and the ICC, by making ecocide a fifth crime against in international law within the context of the Rome Statute. And that would add a level of deterrence through law. So it's a very innovative approach, and as Jojo Mehta usually says, an additional guardrail to ensuring that we limit through criminal law and we deter people who would conduct environmental harm. We're in Africa. We're now joined today by people from across Africa, natural justice, we have people from natural justice from different organizations and activists and policymakers across the globe and in Africa, and we'd like to continue this conversation. In that stead, I would like to introduce Jojo Mehta, who is a co-founder and Chief Executive Officer of Stop Ecocide International, who will describe to us the history of Stop Ecocide International and will let us know what Stop Ecocide International has been doing all over the world and perhaps now suggest what we can possibly do in Africa. Thank you and welcome, Jojo.
Thank you so much. Greetings to you all, and thank you for this opportunity. It's a privilege to be introducing this topic in such illustrious company. Stop Ecocide International is an expert advocacy organization with one highly specific purpose: engaging governments towards the recognition of ecocide as an international crime. We underline its potential for deterring destructive practices, protecting Earth's vital ecosystems, and catalyzing positive system change. And we help to convene and to map the diplomatic collaborations and progress towards adoption of the law. In 2021, an independent expert panel that was convened by our charitable foundation proposed a definition of ecocide: unlawful or wanton acts committed with knowledge that there's a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. And this could enforceably address harms such as severe chemical pollution or oil spills and mass damage to climate-regulating ecosystems, forests, ocean, mangroves. And it has triggered legislative developments and proposals of law all around the world in the last 3 years. Why is it that this law is gaining so much attention right now? Are there not already plenty of environmental laws? Well, yes, indeed there are, but they are mostly in the regulatory rather than the criminal sphere, and they are often poorly followed, poorly monitored, and badly enforced. And we dedicate ourselves to this particular initiative of ecocide law because we believe that recognizing the worst harms as crimes will make a huge difference. If decision makers know that breaches of regulation, which also threatens severe damage, could lead to personal criminal liability, this creates a genuine deterrent. It will have a transformative effect on project planning as well as policy making. It will enable foreign investors and extractive corporations to be and to feel accountable at the highest level. We believe it will also help to address a mindset that has developed over centuries. It's the mindset that produced the Industrial Revolution in my own country, the UK, a mindset that sees the natural world as nothing more than a bank of resources to be extracted and exploited. And particularly in countries where those natural resources are in abundance, that bank of resources has also included people. The systematic destruction of nature and the attendant human rights violations are the logical consequence of this acquisitive and colonial approach, and it has led us to a situation of profound global crisis. Even those who have most profited can no longer ignore this. Ecocide law presents us with an opportunity to rebalance. When we name ecocide as a serious, even an international crime, what we are saying is it is just as bad, just as wrong, just as dangerous to destroy nature as it is to destroy people, and that indeed it ultimately comes to the same thing. We believe this law will hold to account those who fail to come to that understanding, not ordinary people on the ground, but those in key decision-making positions. This conversation is advancing rapidly in individual jurisdictions around the world, from Belgium to Brazil, at regional level in the EU, and also at the level of the International Criminal Court, where a growing number of states are showing interest, from the Pacific to the Caribbean to Africa. So this webinar today is a very timely opportunity to explore various legal and cultural aspects as discussions gain momentum at government level around the world. And from our experience working with this topic, I have no doubt that today's conversation will stimulate both useful questions and positive action. And I'm very much looking forward to hearing from our distinguished panelists. Thank you very much.
Thank you very much, Jojo, for that very impressive introduction to what ecocide law is and what Stop Ecocide has been doing over the years. I think that's a very good pace setter for our discussion today. Next, I would like to invite Judge Haykel Ben Mahfoudh, who is from Tunisia, but he's a judge of the International Criminal Court and has very many academic accolades, including the publication of a book titled The Environment and International Law. He is very open as a judge, and he's very passionate about the topic of ecocide, and we've had discussions with him for quite a while. Welcome, Judge Haykel.
Thank you very much, James. And thank you all for this kind invitation. Good afternoon from The Hague. I'm very happy to start, to be part of this webinar, since it coincides with the beginning of my office as a judge at the ICC. It's been now a week that I'm officially taking my office officially, and it's my first public event. So I'm very, very happy to be with you today. Thank you for the invitation. As you mentioned, James, we had several conversations on the topic, and you've been involved also with us during the campaign when we had this side event at the UN headquarters together to promote the ecocide and the criminalization of ecocide, the fifth crime. Let me begin with a few key points on preliminary observations, and then I will come maybe on a more African perspective how to deal effectively with this with the topic. Recent trends show an increase in the intensity and the frequency of extreme, massive damage to the environment and climate events, and these have a significant impact on, as you mentioned in the introduction, on the small island states, but also the African continent itself is very much concerned. And here we are at the center of human rights being affected and violated by global warming, climate change, but also the nature, the environment, and the species themselves, which have the right to be protected. And this occurs despite several, existing national and international environmental law, but their inadequacy in protecting our well-being is evident. So recognize it, and here I want to go straight forward to the topic, recognize that ecocide as a fifth international crime under the Rome Statute has gained momentum as a means to protect nature, and acknowledge its intrinsic value. Here we are talking about protecting nature per se. So, sorry for the interruption. I was saying that in response to any massive destruction of the environment, a definition has been coined, as it was mentioned in the beginning, of ecocide as an international crime. And adding ecocide as an international crime alongside genocide, crimes against humanity, war crimes, and the crime of aggression conveys the gravity of large-scale environmental destruction. This is a significant challenge to be really achieved within the framework of the Rome Statute, to get, the crime of ecocide effectively prosecuted under international criminal law. The question is how this framework, the ICC framework and the international criminal law framework, can be effectively employed to hold accountable individuals and entities involved in the purposeful environmental harm, and then strengthening mechanisms for addressing ecocide and associated environmental offices. Too quickly, because we don't have enough time, expansions of the expansion of the ICC subject matter jurisdiction to crimes against environment. This requires the amendment of the Rome Statute, and this is meant to equate serious offenses against the environment with the existing international crimes under the Rome Statute. And for that, we need to recognize the fundamental principles that attribute irreversible damage to the environment with the same level of severity as other international crimes. In addition to that, move beyond the confines of the environmental justice movement and adopt a broader legislative approach on the national level as well. This involves considering whether the Rome Statute can pave the way for legal reforms or if alternative approaches should be explored. And here I mean by that, or refer by that, whether we should go on amending the Rome Statute or rather adopt another international treaty or convention with the subject matter of ecocide. So there are different amendments if we go on the first option to be added to the Rome Statute, whether in the preamble or in the substance matter. Quickly, last point that I wanted to deal is about the question to answer, try to answer the question of the feasibility of preventing, repressing, and ultimately adjudicating cases of ecocide on the basis of how the crime is defined and how the crime, the definition was coined. And I think that the justiciability of ecocide extends beyond its definition. It relies on a multifaceted approach involving legal clarity, international commitment, and effective enforcement. To serve these purposes, it is crucial to establish a strong link between ecocide and environmental justice. 2 points here, and I will stop there. The first one is by linking ecocide to environmental justice. This would reinforce the protection of the rights of communities and ecosystems, no matter who is affected by the environmental harm. And the other thing is that it allows to prevent ecocide or to align ecocide with the principles of environmental justice, and therefore ensuring that vulnerable communities are not disproportionately burdened by environmental destruction. So the idea is that deterrence is amplified when potential perpetrators understand that ecocide is not only an environmental offense, but also an offense against human rights and environmental justice. Later, I can, during the conversation or the discussion, I can add more, let's say, substance on the African maybe perspective on how to integrate ecocide within the African regional legal framework. Thank you very much, and sorry for the technical, let's say, concerns that we've gone through during the presentation. Thank you very much once again.
Thank you so much.
Thank you very much, Judge Haykel. I'll hand over to Nnimmo.
Amazing. Thank you so much, Judge Haykel. Well put, ecocide is not only an environmental concern, but a concern that deals with human rights issues in their entirety. That was really a comprehensive account of what we're talking about at its core when we mention the term ecocide and ecocide law. And these definitional discussions from a legal context are really important in allowing us to be able to recognize with absolute certainty and clarity what does fall and doesn't fall within that specific definitional ambit, and therefore empowers a lot of lawyers and practitioners worldwide as to how to use our legal mechanisms then more appropriately in mind of that definition. Please allow me now to introduce our next speaker, and that is Dr. Nnimmo Bassey. Nnimmo Bassey is a Nigerian architect, an environmental activist, author, and poet who has chaired Friends of the Earth International from 2008 through to 2012 and was the executive director of the Environmental Rights Action for 2 decades. He was one of Time magazine's Heroes of the Environment in 2009, and in 2010, Nnimmo Bassey was named a laureate of the Right Livelihood Award. And then in 2012, he was awarded the Rafter Prize soon after. He also received an honorary doctorate from the University of York in England in 2019, and he serves currently on the advisory board and is the director of the Health of Mother Earth Foundation, an environmental think tank and advocacy organization. Please assist me, ladies and gentlemen, in welcoming to the digital platform and podium, Nnimmo Bassey.
Thank you so much for that very elaborate introduction. It makes me feel like who I am, that is a living ancestor. And thanks a lot for inviting me. Thanks, James, thanks, Jojo, thanks everyone for being with us in this discussion. The ecocide law idea is one thing that's given me hope after so many years of being an environmental justice activist. Sometimes it looks like there's going to be no way out, nothing to really hold on to in the struggle. But ecocide law, when it comes to effect, to me, is a real platform by which we can hold all those who are causing reckless harm to our environment and to our peoples accountable. So this is really one reason for hope, and I hope that it comes to pass sooner than later, because as we speak, the forces of exploitation, of mindless destruction from extractivist activities, mining, oil and gas, is going on unchecked. Sometimes we find our leaders turning a blind eye to these very harmful activities because they're just interested in the foreign exchange that comes from extractivist activities. Countries dream of wealth, of the good life, and so they permit the absolute rape of our environments, culture, spirituality, and everything. So ecocide law comes to the rescue to at least get everyone to know that we can't carry on the way we are going without consequences. And I believe this would tear off the corporate shields and bring all those who hide behind corporate barrier, corporate shields to account. Now, my contribution is easy. I will just speak. I've had the misfortune of visiting many countries where very harmful extraction has taken place, but I'll select just a few to give examples and buttress my concern, which I believe should be the concern of every human and every other living being on the planet, because we are so interconnected. And when the environment is damaged, it damages everything, and that affects everything and everyone. I could start from the Niger Delta, but let me close with the Niger Delta. Let me start from Senegal, which is one country that really brings hope to many people on the continent. Very young leaders elected in circumstances that really gladden our heart. But they come into office with a legacy of oil and gas finds. And recently, I was with fisher folks at St. Louis, Senegal, and they were you could see the platform just close to the shoreline. And the fact that they're going to lose their rights to maintain their fish pods, to fish in that area, and then, of course, the pollution that will come from gas extraction. And then oil well is being sunk in the Saloum Delta. Saloum Delta is one of the most eco-diverse regions in Senegal and in Africa, and is a UNESCO heritage site location. And once the claws of the drills from the oil companies sink into that delta, then what we've seen in the Niger Delta could very well be replicated there. It's like an assault on the deltas. If you look at what is going on also in Okavango in Namibia, it's an area with indigenous communities. People depend on natural environment, their water bodies, their total environment is being threatened by crude oil extraction, exploration in that region. And then we come to Uganda, the Lake Albert region, Albertine region, where all very heavy crude is being extracted. It's also a national reserve, protected area. But you know, when these extractivist activities commence, the idea of respect for the environment, of national protection, global heritage status become nothing. And within this, the recklessness that comes from extractivism. And so the problem with the idea in Uganda, which has been, of course, globalized with the struggle against the East African crude oil pipeline, EACOP, is that that pipeline that will go from Uganda to Tanzania, of course, highlights one of the colonial legacies of Africa, that our resources are always extracted for export. Along the entire coastline, export pipelines for export, everything, railway lines go to the port for export, and this causes some problems for the people. But beyond this, the heavy crude coming from Uganda will have to be warmed up 10 times along the pipeline before it gets to Tanzania. And it's passing by the western shoreline of Lake Victoria, the biggest, the largest freshwater lake, inland water lake in Africa. And it holds the threat that the watershed could be contaminated and would impact about 40 million Africans who depend on fresh water supply in that area. And so that is ecocide in the waiting. We could also speak about the Democratic Republic of Congo. We know Congo has been in conflict situation right from beginning with the execution of assassination of Lumumba, and what happened even in pre-colonial times. As we speak, very so-called critical materials are being extracted, people are being displaced, environment is being damaged, there's no control, there's no law, no enforcement of the right of the people to a safe environment. So the Congo can be said to be a very practical template for if you want to study ecocide in action. That is what you will find all over that region. And now I come back home to Nigeria. I come from the Niger Delta, and I've been campaigning in Nigeria. I was inspired to be an environmental activist when Ken Saro-Wiwa was campaigning for the rights of the Ogoni people. And my resolve was consolidated in 1995 when he was executed along with 8 other Ogoni leaders. And what was he talking about? He was asking for accountability for the pollution of Ogoni environment. In 2011, the United Nations Environment Program published a report of the assessment of the environment that Ken Saro-Wiwa had complained about and for which he was executed. And the UN Environment Program confirmed that the water bodies of Ogoniland were all contaminated. That in many places, soil was contaminated to a depth of 5 meters. And we talk about oil spills in creeks, in wetlands, in swamps, as well as gas flaring from giant furnaces polluting the air all over the region. And today, or just last year, another report was issued by the Bayelsa Oil and Environment Commission for one of the states in the Niger Delta. And it showed that there was a per capita oil pollution of 1.5 barrels in that state. I mean, it's inconceivable that a whole region can have that level of pollution. And the impacts are clear. The water bodies are contaminated. They are physically, you can see the pollution coating the entire surface. The fishery is destroyed. The land is polluted, and people are cultivating crops and eating from the crops. Life expectancy is an abysmal 41 years. And, produced water and toxic waste are dumped in open canals around the area. And this is possible because nobody is held accountable for that pollution. And whenever the corporations are taken to the law court, they end up sometimes agreeing to accept that they've committed some harm, but then they'll couch this as though they're doing something humanitarian, and they pay a token to compensate. But the harm remains undone. And so right now, the major oil corporations, Shell, Chevron, ExxonMobil, the Eni, and the rest, they're embarking on what they call divestment, to sell off their onshore oil fields and move away either into deep waters or simply ship away with their profit. but the oil spills and the damage done for over 60 years, they are not doing anything about it. So the campaign for us is that before any oil company would abandon the oil wells in the communities of the Delta, they should clean up the mess, restore the environment, conduct a health and environmental audit, and then make reparations. So it's cleanup, remediation, restoration, and reparations. And this would be this would then give them the license to go somewhere else. Otherwise, they're selling these fields to local companies who are even less accountable than the international oil companies. And so the situation where a whole people, over 40 million people, are sentenced to live in an environment that is killing them, where the right to water, which was agreed to at the United Nations in 2010, is not adhered to, is something that we find completely unacceptable. So having ecocide law would, for once, give all of us the tool, the platform to say, you've killed us for long enough, you've contaminated it for long enough. Now, whatever you do that adds to these harms, you have to account for it. And I don't see a better way to go about it than to have this law. I have my problems with also with the international legal system, with some countries behaving like outlaws and some people being above the law, not respecting whatever decision comes. But I believe that this would help us to go beyond that, because the environment respects no territory, no boundaries, no geographic boundaries, and everyone, we're all on the same boat for once, in one consideration. And ecocide law is something that we can all hold on. And I believe that this conversation is extremely important, just to again affirm that we are committed to make this happen. Thank you.
Thank you so much, Nnimmo Bassey, for that apt account on just giving us exactly how ecocide relates to the African context and the number of really grave issues and problems and impacts that we've been having as a result of this fossil fuel expansion on our continent. I'm just looking at the time. I'm going to introduce our next speaker quickly. Our next speaker is Mr. Lucien Limachet, who is the Head of Litigation and Defending Rights at Natural Justice. Mr. Limachet will touch on the current landscape of environmental laws.
So good afternoon, good evening, friends and colleagues and distinguished participants. Just want to say a quick thank you to Alka and, of course, Stop Ecocide for hosting this very important topic that is currently being discussed internationally and on the regional continent and on the African continent. As Nnimmo stated, I'll be delving into the past and currently looking at what is happening in Africa when we look at the environment and the development of environmental criminal law. So, spanning across 30 million square kilometers and home to over 1.2 billion people, Africa is a kaleidoscope of richness and diversity. Africa has had over 3,000 communities with their own unique language, cultural and traditions. Africa houses nearly 1/4 of the world's mammal species, 1/5 of the world's bird species, has 65% of the world's fertile lands, has 8 out of 11 biomes, has 10% of the world's freshwater resources available to the people on the continent. Africa is also recognized as one of the most beautiful continents and having multiple World Heritage Sites and Cultural Heritage Awards. Africa also has roughly 30% of all mineral resources, 8% of the natural gas reserves, and 12% of the world's oil reserves. Although some would say with the current exploration for further oil, this number's starkly much higher. And I think with Nnimmo saying, that we've got all these pipelines that are being built, and in fact, there's been 5 new announcements of new pipelines that are even going to be bigger than the one that was referenced going through Uganda and Tanzania. I think we know what's coming to the African shores around oil and gas. So as a result, of course, of this incredibly rich continent, it's also what has attracted the destruction of such richness. And I think what's really apt here is if we look at Thabo Mbeki's quote in the speech, "I'm an African" at the Parliament in 1996, he said, "I've seen the corruption of minds and souls in pursuit of an ignoble effort to perpetuate veritable crimes." And I think here it's specifically referred to the environmental crimes. So according to United Nations Environmental Program, environmental crimes are the 4th world's largest form of organized crimes, behind only drug trafficking, counterfeiting, and human trafficking. In terms of the Global Investigative Journalism Network Africa, in terms of, in terms of the Global Investigative Journalism Network, Africa has not been shielded by such crimes. And each year, the continent loses an estimated $195 billion through illicit financial flows, illegal mining, illegal logging, illegal trade in wildlife, environmental degradation, loss of biodiversity, and of course, lawful developments, but unenforced implementation of the laws to hold corporations accountable on such developments, like Nnimmo was referring, holding companies accountable in the Niger Delta. The impact of these crimes has left Africa in a position where Africa has lost more than 3 million hectares of biodiversity, large portion of fresh water is polluted, 45% of fish are being overharvested, and upliftment of the 3,000 different type of communities that we see on Africa have not been realized. Currently, Africa is one of the poorest continents and continue to be exploited for their resources. If we continue to operate at this level of exploitation, Africa is geared towards serious impact around food starvation, livelihood destruction, and of course, extreme poverty, increased in extreme poverty. Looking at all of what I've just said, the first development of international environmental law in Africa was the signing and ratification of the General Act of the Conference in Berlin and the signing of the ratification of the London Convention. Both laws revolved around the preservation of wildlife and fauna, rather than taking into consideration thematic issues around environment, colonialism, and the anthropocentric use of the environment. Only when the Algiers Convention was signed in 1969, and further when Africa held its regional seminar on human environment in 1971, in anticipation of the United Nations Stockholm Conference, were these issues starting to be really discussed and explored. The above analogy of how environmental international law was developed on the African continent is remarkably similar when applying the national laws to the 54 countries around environmental criminal law. Most of the crimes that were presented at court before 1950 were so-called green crimes, which were geared towards illegal poaching on fauna and flora. These crimes were also geared towards small-scale subsistence hunter-gatherers or indigenous communities who respected the environment but who also were reliant on the environment for their livelihood, rather than focusing on the larger hunting syndicates or corporations who were exploiting Africa for the betterment for their colonial captors. There was very little criminal laws that took into consideration the real issues around the destructive anthropocentric use of the environment for the benefit of other countries outside of Africa. Luckily, the previous implementation of criminal law has changed. Since 1990, which is generally considered the second phase of development of national environmental law on the African continent, most countries now have laws that look into and connect climate issues, loss of biodiversity, pollution, defining what sustainable development and the risk they might have on humanity in Africa. These laws are your typical laws geared towards environmental management, climate change, protection of the environment, incorporating various international principles such as future generation, common but differentiated approaches, the precautionary principle, environmental justice principles, and of course, the polluter pays principles. Of course, all of these laws then would also be incorporated the various environmental clauses or statutes that might occur from any violation of those laws. Currently, in Africa, there are 3 broad types of environmental crimes that can be prosecuted. You have green crimes, referring to large destruction of logging, of forest or large poaching operations, brown crimes, which are your typical pollution-related crimes, and of course, blue crimes, which are your water-related crimes. During this period, and although there has been a huge advancement in the development of environmental law and making certain actions criminal when violating those laws, there is still very little prosecution of pollution or degradation of the environmental crimes, which are crimes that are having the largest impact on the environment. As Nnimmo highlighted, we still yet to have serious prosecuting cases that have really driven a change in how we do business on the African continent. To date, there are maybe a handful of cases in each jurisdiction, and I think that is an exaggeration, that have prosecuted corporations for the damage to the environment. There are a couple of reasons, though, why this might be, over and above the typical ones that I think we know. So there is very little funding, support, and will by the state to hold companies accountable. We know that states fund governments, they fund their campaigns, and they obviously provide rich endorsements in order to make sure that certain developments are approved. And of course, that makes it very difficult then when you have the same branch of the state who needs to prosecute to hold those accountable. There's, of course, not enough resources around evidence, and the evidentiary burden is quite often very difficult to prove because there's not enough resources geared towards providing evidence before the courts. Functioning judiciary and case prioritization. There are certain jurisdictions in Africa around judiciary who just do not have the capacity to understand and comprehend the type of cases that need to be brought in order to hold corporations accountable. Most pollution cases that we look at when we want to hold them accountable requires a lot of secondary evidence and requires an inordinate amount of expertise that can actually prove that such degradation has occurred. Even though it might seem quite obvious to the layman at court, of course, the burden is so high, you need to make sure that the expert evidence is basically airtight and cannot prevent any loopholes for the defendants to run away with. And often this results in a scale of how many experts we can bring to disprove the other experts. There's been cases on the African continent where you would have 2 or 3 experts for the prosecution, and the other side would come back with 15 experts saying completely the opposite. It becomes very difficult then for the judiciary to make a meaningful judgment that would then obviously hold corporations accountable. And then, of course, the last one is the punishment never really fits the crime. If we look at South Africa, there have been a couple of cases where people and organizations have been held accountable. Most of the time, it's a slap on the wrist, and they get to not go to jail or essentially pay a very small fine, and then hopefully they are on their way to continue the degradation that they're doing. So where has this left us? Well, the lawyers and the NGOs or interested persons have become actually very creative on how to hold corporations accountable. In the last 10 years or so, we have seen cases being pursued in different jurisdictions outside of Africa and inside of Africa. There's a couple of cases where there's been environmental degradation in Zambia, and now the corporations were housed, or the parent company is housed in South Africa, and cases are now being brought before South Africa. Vice versa with companies in England and in Netherlands and in other jurisdictions as well. And we know the French law, La Loi de Vigilance, which has now been enacted, which has allowed also cases to be brought before the French courts for extrajudicial crimes against, impacts against communities when there's been violations of laws. We have also seen the development of private prosecution, which is something that's quite unique, and approaching alternative dispute resolution mechanisms, independent redress mechanisms, and pursuing civil actions. However, not everything is doom and gloom. Since 2010, we have seen African governments starting to prosecute and develop further laws that are holding corporations and government accountable to make sure any type of violations of criminal environmental law are prosecuted. Some companies in South Africa were recently prosecuted, agreed there were private prosecutions, but prosecuted nonetheless. And certain environmental assessment practitioners have been prosecuted as well and are not allowed to participate as a practitioner anymore. We've also seen regional courts starting to hold countries accountable for the destruction of environmental degradation. The so-called Lido case, which was recently heard in the African Court for Human and People's Rights, and of course the famous case Serap in the ECOWAS Court of Justice are clear examples of this. However, I cannot agree more with what Nnimmo said. There's just not enough that's been done by governments to use the environmental laws that currently exist on the African continent. And of course, the impact and the destruction is just increasing, and it's going much more excessively. There are no borders, as Nnimmo said again. And so, we really need drastic changes. And I really believe that this Ecocide campaign to drive this particular change could be one of the gold nuggets that lawyers and NGOs could use on the African continent to make sure that we protect our very sensitive but rich biodiversity and continent. Thank you.
Thank you very much, Lucien, for that very incisive presentation, and with a lot of accurate, facts and figures and demographics around where widespread harm to the ecosystems has happened in different countries. At this point, I'd like to introduce Dr. Chilenye Nwapi. Dr. Chilenye is a legal advisor in the Department of Oceans and Natural Resources at the Commonwealth Secretariat. He's also very well versed in environmental sentencing and creative sentencing, and holds a PhD in law from the University of British Columbia. He's a barrister and solicitor as well of the Supreme Court of Nigeria. Welcome. And we look forward to hearing your thoughts, Dr. Chilenye.
Thank you very much, James, and thanks to the previous speakers. I think this is a very important topic, and my hope is that one day we'll have an international crime of ecocide codified in international law. The conversation around ecocide has been going on for a long time now. But one aspect of it that has not been much talked about, actually very little. I did some search in the literature. I couldn't find anything on the likely punishment that is required to address the crime of ecocide by the time we codify it. So I decided to dwell on this topic, drawing from research I have done on environmental sentencing at the national level. And so I'm going to cover about three issues. One of them is to discuss why ecocide needs a unique penalty regime, and also to discuss creative sentencing as a viable sentencing approach for ecocide. And lastly, I will look at the Rome Statute and how the penalty regime in the Rome Statute might be expanded to address the uniqueness of ecocide as an international crime. We are talking about punishment because ecocide is unique. It's not like other crimes. Its uniqueness stems from the fact that the victims are quite varied. It's not just theft. It's not just humans that are robbed or killed. The environment, other mammals, nature, all of these are victims of ecocide. And so in thinking about the appropriate penalty to address the crime, I think the unique nature of ecocide needs to be taken into account so that we don't end up designing a penalty regime that allows either only fine and imprisonment, punishments that do not actually in any meaningful way address the crime in question. And so there is need for a unique penalty regime for ecocide, a penalty regime that is attuned to the type of offense, to the nature of the offense. So we need punishment that is well attuned to the nature of offense, looking at the victims of ecocide. There is need to also decongest the prisons. There are too many people in prisons. Sometimes we have to wonder whether sending people to prison actually does society much good. It's often more punitive than conferring any benefits to the public. There is also a need to provide the offender the opportunity to do some good. Someone who has destroyed the environment, in designing the punishment, I think it's in order to provide the offender some opportunity to do some good, or remedy some of the harm that has been caused. And also there is need to enable positive action to follow the offender's crime. Someone who has violated the environment can be provided an opportunity to engage in some positive action. Let's derive some good from the wrong that has been committed. And so for my research so far, I found the concept of creative sentence as a viable mechanism to address the issue of punishment with regard to the crime of ecocide. Creative sentencing has been around for a long time, so it's not new. It has been used in several aspects of criminal law, especially in juvenile cases. It's quite common in juvenile cases. And from what I have seen, most criminal statutes provide for some form of creative sentencing. The only problem is that the provisions of most criminal statutes are still very restrictive in terms of not giving the sentencing judge the leeway to actually be creative. And a creative sentence is traditionally regarded as a sentence or a part of a sentence that does not include fine or imprisonment. Fine and imprisonment are the traditional forms of sentence. So when creative sentencing is talked about, what is being referred to is something that goes beyond the traditional fines or imprisonment. Of course, fines are a major component of creative sentencing, but it's no longer fines that are deposited into the general government coffers. It is fines that are applied in a creative way to see how the harm that is caused can be directly addressed. And so when it comes to creative sentencing, instead of requiring an offender to pay fine into government coffers or to be imprisoned, the sentencing judge is authorized by statute to develop other sentencing options that can better serve the ends of justice in individual cases. And so the judge has a lot of discretion rather than statute prescribing all the possible punishments to be considered. The judge has a lot of discretion to consider other forms of punishment. And so within that context, the judge is allowed to be creative in developing the appropriate sentence to be imposed on the offender. I looked at many jurisdictions: Canada, Australia, Brazil. These are the 3 countries that have been quite popular with creative sentencing, especially in environmental cases. And so I went through the literature from those countries as well as the legislation, the criminal law legislation. I identified a number of creative sentences that the courts in those countries have handed to offenders. Among them are another mandating the offender to channel funds to a cause that is beneficial to the community that is affected by the offense. So instead of the traditional fines, the fines are directed to be channeled to some cause that is of benefit to the community that is affected. For instance, mandating the offender to fund research to support environmental remediation or environmental restoration, funds to support the development of cures for illnesses that are caused by the offense. I remember I think the Mercury incident in Nigeria. That's a classical case where creative sentencing would be appropriate. Instead of fining the offenders, asking them to pay millions of naira or dollars to government coffers, a creative judge can design a program that will support developing cures for the illness that was caused by the mercury, or also supporting research, other forms of research that will promote better environmental protection within the community that is affected by the offense. In some instances, creative sentencing judges have ordered payment of expenses that are associated with the investigation of the offense. We all know that some of these offenses that qualify as ecocide, they are difficult to investigate. They are mostly committed by corporations. Individuals rarely have the capacity to commit these crimes to the extent that corporations can commit them, especially in terms of scale. And so it's quite expensive to investigate these crimes. So a creative sentence could comprise ordering payment of the expenses that are associated with the investigation of the offense. In one instance, a judge has ordered an offender to build a recycling center. Because the offense had to do with recycling. So the judge ordered the offender to build a recycling center. Funds have also been ordered to be provided to support students who are conducting research in fields that are relevant to the offense. One of the beautiful things about creative sentencing is that these sentences are often given in addition to the traditional fines and imprisonment. So they are not exclusive. The fact that the offender has been imprisoned does not mean that the creative sentencing component should no longer be added to it. An offender can be jailed while also paying these creative fines that will help to address the offense. And so I found that creative environmental sentencing is widely used in Canada, in Australia, and Brazil. In the US, it is quite widely used in juvenile cases. My research has not shown me consistent use of creative sentence in environmental cases there, but in Canada, it's well used, in Australia and Brazil. I have an upcoming, forthcoming paper that will be published before the end of the year by Miguel International Journal. So what I looked at was the use of creative sentencing to promote sustainability in Nigeria. So I looked at the environmental situation in Nigeria, reviewed the environmental laws all the way from the cocoa incident in Delta State, which was about the dumping of toxic materials in Nigeria. So I reviewed all the laws, including the oil and gas laws, the criminal code that have some criminal law provisions. So what my co-author and myself have done is to assess the use of creative sentencing to promote environmental sustainability in Nigeria. The paper will also be relevant to other African countries. So these are the some of the research findings that we have made in terms of how creative sentencing can be better used to promote or rather to address the crime of ecocide. Then the next thing I did was to look at the current state of international law. And so I looked at the Rome Statute of the International Criminal Court. I looked at the penalty provisions. And there is some room for creative sentencing in the penalty provisions of the Rome Statute, but the powers given to the judges are not wide enough to exercise adequate creativity in cases of ecocide. Imprisonment is provided for under Article 77. Imprisonment can be a maximum of 30 years or life imprisonment. There is also provision for fine. There is provision for forfeiture of property or proceeds of crime. And then the creative component of the penalty provisions of the Rome Statute includes reparation for victims, restitution, compensation, and rehabilitation. Now, if the crime of ecocide is adopted, I think there is need to provide the judges of the ICC more room to consider other forms of sentencing that will help to address the very offense of ecocide. Reparation for victims, restitution, compensation, rehabilitation, they are good, but then victims will have to be redefined to include nature and the environment. That is now what is missing in the Rome Statute, because the victims traditionally is about communities who were affected, individuals who were murdered or injured by the acts of the offender. And so as we move along in our conversations with adopting an international crime of ecocide, we should also be thinking of the punishments. It's very critical to the crime of ecocide because it doesn't really benefit societies that much if a person who commits ecocide is sentenced to life imprisonment. It doesn't really add much benefit to the community other than deterrence. But we need direct benefits to the community. We need benefits to the environment. How should the offender be punished? In a way that the environment that is the victim would benefit from it. Some remediation can be carried out through the punishment. So that, in my opinion, is the way forward as we go along with our conversations and our push and lobbying to codify the crime of ecocide in international law. We should not forget this very important aspect of it. Otherwise, it's going to be an opportunity lost. And once the law is codified, it's quite difficult to revise or amend them. Thank you very much, and I appreciate the time.
Thank you very much, Dr. Chilenye, for that very incisive delve into creative sentencing and various options. I think we've learned quite a bit from that, things that we hadn't perceived before. So this is very important. I then hand over to Norma to introduce Apollinaire, or is Patricia on the call? Patricia? Norma, please go ahead.
Thank you, James. Thank you, ladies and gentlemen. I've seen that we're currently running outside of our time, and if you could please indulge us for just 15 more minutes, we would greatly appreciate it. This has obviously been a very exciting topic, and there's just so much to talk about and discuss, as you've heard, so many angles and interesting viewpoints. Our next speaker is Apollinaire Oya-Usu-Leo. Apollinaire will be giving us a detailed account today on the theme in relation to the protection of Indigenous peoples' rights. Allow me to give you a little bit of background about him. He is the founding member of the African Earth Jurisprudence Collective and president of the GRAB Benin. Apollinaire has a basically founded this organization with a broad focus on reviving the Vaudan tradition of the region and connecting young people with nature. In 2012, he helped to secure the first sacred forests law in Africa, and from 2014 to 2017, Apollinaire trained to become an earth jurisprudence practitioner with the Gaia Foundation, during which time he began to work directly with the custodians of sacred national sites. Apollinaire, please take to the floor.
Merci beaucoup. Je pense que
Thank you very much. I am so happy to be able to share with you this moment for such an important topic, because this concerns us all. We're talking about ecocide, we're talking about the destruction of the environment, but also our own destruction, because ecocide refers to the destruction of what is human and what is not. So this is an increasing problem in Africa, and for us indigenous people, we directly suffer the consequences of the destruction of our way of life and of our environment. Most of indigenous peoples, and especially in Benin, our way of life and our beliefs were based on ecosystems. This is our tradition. We have our tradition of voodoo. Some people have dramatized and diabolized voodoo, but voodoo tradition is based in the link between the ecosystem and the human beings. We recognize the right to water, the right to air, the right to earth, and the right to fire, and the right to forest. Voodoo allows us to realize that we're born together with other animals and plants, and the idea was put in place through the concept of totems. But today, ecosystems are destroyed and the environment is destroyed, and this is the same as destroying our ancestors, because we believe as indigenous people from Benin and from other places, we believe that dead people or those deceased are not deceased, they are part of the ecosystem. And we live in freedom together with animals and with plants. And these animals and plants allow us to be fed and to breathe. However, unfortunately, we have started to destroy all this. I think that deforestation, I think that mineral exploitation and pollution have really spoiled our life, not only in the north and not only to humans, but also to humans. So I think that the law on ecocide is our potential. This is what would allow us to see how responsible we are regarding our present life and our future life, because for a long time, human beings have been selfish. They have just developed laws in order to defend themselves in an anthropocentric approach, because nobody took into account ecosystems. We started building our own prisons, our own jails, and starting with our own houses, because we are locked inside our houses, we lock our own rooms, whereas animals live in freedom. I mean, we wanted to destroy all of this. And today, the law on ecocide would be a law that would allow us to live in justice. And it would allow us to live. As I said, nature can live without human beings, but human beings cannot live without nature. In other words, destroying nature is not only destroying the environment, it's not only damaging ourselves and humans and non-humans, which are the basis for other lives. So today, we need to work in order to get this international law on ecocide applicable to all countries. This would be for us indigenous peoples something very beneficial because it would allow us to protect the land of our ancestors. It would allow us to see the connection between the visible world and our link with nature. It would allow us to decide whether we want to make projects, but today there are many projects which are not sustainable. So this ecocide law would allow us to have a framework to protest against non-sustainable projects, because sustainable development takes into account of economic, social, cultural aspects, but also spiritual aspects, because the visible world is directed by the invisible world. And I think that this ecocide law would protect us and would protect indigenous people against harmful and destructive activities. And now if we think about our natural resources, we have a link with our resources. You know, if you are born in an indigenous community, I am Toli and I'm the king of Toli. This is an ethnic group that lives thanks to seeds. We receive seeds, we receive totems. You will see in my hat, in the hat I am wearing right now, there's the symbol of the panther, and I have to protect these animals. Now, if we criminalize people, this law on ecocide will allow us to protect our spirituality and to protect humans, non-humans, and future generations. And this will also favor a sustainable use of our resources, because there will be, loss of diversity will be prevented. Today, we are witnessing, in a passive way, we're witnessing how resources are disappearing, and we see how species are disappearing, how they're becoming extinct, and all this because human beings live in this spirit of consumption. We think that we're entitled to do anything we want, but this will go against us. And something else, I think that the law on ecocide is going to reinforce indigenous peoples when it comes to their beliefs and to their human rights, because we are vulnerable communities. We're considered to be fragile communities, but this ecocide law would allow us to have a stronger position when it comes to negotiating in front of corporations. Sacred forest, this is our library, this is our lab, this is it's our medium, it's the way we live, actually. So whenever somebody comes and says, well, there's a project with this forest, well, we could prevent this from happening. And there are governments who are influenced by corporations, and they're influenced to lend these pieces of land to people who are just interested in exploiting this. And today, we do not think about future generations. So I think that this law on ecocide would allow indigenous people to participate much more in decision making. I think this is also what we want. This is our commitment for today. We're facing so many challenges, and we need to act together. And the air that we're breathing in Nigeria, the air that we're breathing in the United States, well, this is what I do not want to buy. And if we have to keep buying things in order to survive, you know, when we destroy everything, it's like as if humans were enslaved again. So we need to make this ecocide law operational. We need to make it enforceable. Otherwise, we're going to destroy whatever is human and whatever is not, because we're all part of this ecosystem and of this biodiversity. And the time will come when human beings will not be here anymore. And this is not utopia. And if we push the limits of nature, the nature is going to react. We see the effects of climate change in many countries. So we need to stop this, and we need ecocide to be punished just at the same level as genocide. Genocide is only part of the destruction which is undertaken, because we're talking here about the destruction of human beings, but also animals and forest, a sacred forest. And when a forest and the ecosystem disappears, we have no longer history, we have no knowledge anymore. It's millions of years of biodiversity loss and the loss of knowledge, ancestral knowledge. So this is what I wanted to say today. It is crucial to raise awareness amongst communities so that the right to live is a matter of concern. So all of this through the ecocide law. We also need educational programs for our children, because the crimes that we have committed in the past, well, we are transferring this kind of crimes to our children through all these practices. I think that we are transferring these practices that lead to the destruction of resources. And we need children to be empowered and not to be vulnerable. We need them to preserve life. We need to educate them so that they can transfer life the way we received it. And we also need international collaboration so that this crime goes beyond the national borders. We need to act in the framework of an international cooperation, because, you know, whales, they're present in Antarctica, but also in the North Pole. So whenever we think about protecting our country, we need about protecting the entire planet, and we need to remain in the dimension of complementarity. This law must be a reality everywhere in the planet, because this is the guarantee for our survival tomorrow. So I think ecocide is the future, and we need to fight against human crime, and we need to protect indigenous people everywhere. And I think about my country, Benin, because I think that many people are migrating towards other areas because their ecosystem has been destroyed. So we need to reinforce the legal mechanisms to protect the environment. So this law could contribute to do that, and it could contribute to preserve ecosystems and traditional ways of life of indigenous peoples. And all this depends on collaboration between local authorities, governments, and all the peoples in the earth. So this is what I wanted to tell you. Thank you very much.
Thank you very much, Apollinaire. Those are very incisive views, particularly on, we shouldn't as human beings test the limits of the environment, otherwise there will be no earth to live in. And you sort of delved into the ecocentric approaches to environmental protection, as well as the anthropocentric ones. And we're very grateful for your perspectives on the indigenous people and how that really works to protect the environment, and because indigenous people rely on the environment for their livelihoods. Thank you very much. I think we've come to the end, not of the webinar, but that was the last speaker. And we should now go into a question and answer session. There are some questions that have already been posed in the chat, I think, as we were going along, but I would invite the participants to just put their hands up, and we let you in to discuss or to talk about any questions you have, any clarifications you seek, but also any input you have into this conversation. Are there any questions in the chat?
James, I did come across a couple of questions, but Jojo seems to have done an amazing job at responding to most of them. I could pull up one question maybe that wasn't addressed. It came from Jan Glazelski. I hope I'm pronouncing that correctly. It had more or less to do with Judge Haykel's synopsis of this conundrum that we have, choosing whether to approach an amendment of the current Rome Institute, the Rome Statute, or choosing to create an entirely new international instrument dedicated specifically to ecocide law and that conundrum. That was the generality of that question.
Yes, there was also a question to Lucien from Arnold Sunga, and Arnold Sunga asked whether, in your exploration and the exposition of these different facts and figures, whether that data is available to be used for advocacy, for ecocide law, for environmental protection, and even possibly litigation. Lucien, would you talk to us about data, the data to support your arguments?
Yeah, sure. So that data is available, and it's essentially just doing desktop research across the various platforms that I have access to. So it's kind of pulled from different areas, but what I'll do is I'll put a list of where I got most of that data and information from, and then we can send it out for those who are keen to connect and have a look at that information.
Thank you. Thank you very much for that. I would like to, at this point, ask David Barisa from the Network of African National Human Rights Institutions to ask a question. David? We seem to have lost David. So we'll just continue looking at the chat.
I wonder whether Judge Haykel might take that first question.
Judge Haykel has just mentioned that he had to leave.
Yes, I'm back again.
Oh, okay, great. And it's very clear now.
Yeah, because I was struggling with the settings for roughly 30 minutes.
Oh, thank you, Judge Haykel.
Yeah, it was a wonderful conversation, and congratulations to all the panelists, and thank you also for the very relevant questions. I will take the question on the amendment, on the legal approach to incorporate ecocide as a fifth international crime. Basically, whether we go for amending the Rome Statute and make it fifth crime, or adopting a separate international law treaty or convention, that means that the states essentially have to agree on either the amendment or the adoption of a new legal framework. And that's the highest, I would say, normative and political challenge. Having said that, if we go on the path or follow the path of amending the Rome Statute, there are some consequential amendments that are required within the Rome Statute to be modified and to reach the requested majority by the Assembly of the State Parties, which is a 2/3 majority. First of all, there should be an addition of a preamble paragraph to the preamble of the Rome Statute, and one of the suggestions was to add paragraph 2 bis, to express the concern that the environment is daily threatened by severe destruction and deterioration, gravely endangering natural and the human system worldwide. That's in the chapeau, in the preamble, to lay down the principle of protecting the environment. Then there should be also an addition to Article 5, to highlight or to reflect that it is the article within the Rome Statute that defines or lists the 4 core international crimes. So there should be an addition to Article 5.1, the crime of ecocide alongside with the crime of aggression, crimes against humanity, war crimes, and ecocide, of course, as a fifth crime, and genocide, of course, and an addition to Article 8 to consider ecocide also as means of unlawful and wanton acts committed with the knowledge, because intention is very important in this case, that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused to those acts. So with that, there's still another challenge, legal challenge, and we'll stop there, which was highlighted by one of the panelists, is about the individual, about the criminal responsibility. Because in international criminal law, responsibility is for individuals and not for legal entities such as corporations and the states. So the challenge is how to cope with that, and making corporations essentially bearing the responsibility for destruction, massive destruction of environment. And that's a very tricky challenge in terms of principles recognition, but also modes of responsibilities as defined in the Rome Statute, because it affects also the way of repairing damage and the type of reparations. And then we can be inspired by the Malabo Protocol at the African level, though it hasn't entered into force yet, where corporate responsibility, penal corporate responsibility, is recognized for some offenses. So this is basically the approach to adopt once it comes to amend the Rome Statute. Thank you very much for the question.
Thank you very much, Judge Haykel. I see there's another question in the chat. It has to do more or less with what persons who are outside of the legal sphere can do. So not necessarily lawyers, but advocates of ecocide and this crime can do to basically assist. Jojo, would you like to respond?
Yeah, very happy to take that one. I think what we've realized over the years is that the key thing here is that this is all about a conversation. Of course, it's politicians who ultimately are the legislators, but no politician likes to be the first person at a party. They want to feel safe having the conversation that is being brought to them. So the more that they hear about it from different directions, and the more that the conversation around criminalizing ecocide, expands in other parts of society, the more important it becomes at the political level. So we would say to people that would like to help to move this forward that if you already interact with policy, clearly that's somewhere that you can bring in the conversation. But if you don't, then there may also be, in relation to whatever organization or work that you do, that there are places that you interact with the public, whether it's articles, reports, events, anything like that. Bringing ecocide law into those conversations is really helpful and important. And also at the private level, within our own networks of families and social networks, but also our own sectors. So it's always another question of bringing this issue and this context and this word, even because ecocide has a very powerful sort of internal momentum to it, is bringing that topic into your sector so that there are new people talking about it. And using the word ecocide to describe that kind of mass damage. All of that is hugely helpful. And we have groups in many different countries who are working on doing this. So please get in touch if you'd like to be more sort of systematic about it. And one final point related to what Judge Haykel was just talking about. Of course, we would absolutely support a convention on ecocide. The reason that we aim specifically for the ICC, for the Rome Statute route, is that it's a treaty that's already in existence, and we know how long it takes to put new treaties in existence. And the statute is already there and already has a protocol for amendment, which has been successfully used. So we see that as a very direct and appropriate route, regardless of what other routes may also be taken.
Thank you very much, Jojo. Thank you very much, panelists and participants. I will now just close by a short summary and then thank all the speakers and participants for coming. I think we've had a very important discussion, and some of the things that have come out are perhaps the need to have another conversation on how ecocide law can be advocated for within the African human rights system and the African regional blocs in Africa, as well as the AU. And in that regard, there is the discussion that Arnold Sunga has brought about the African Court on Human and People's Rights, which Judge Haykel has also talked about. Judge Haykel also discussed, the integrating ecocide law into the African legal framework, but also, integrating this concept of ecocide from an African lens as well, and the African human rights system, but also the interplay between international environmental law and human rights law, which we cannot ignore anymore. Then we had creative sentencing, and there was a discussion about cleanup, remediation, restoration, and reparation as one of the issues after accountability is talked about from Dr. Chilenye Nwapi. So Jojo Mehta has also given us a very good exposition on what ecocide law is, where we want to go as an organization, but also answered a lot of the critical questions that came out of this conversation. So with that, I'd like to thank you all for participating in this. I'd like to thank particularly the panelists, Judge Haykel, Ben Mahfoudh. You have been a very, very strong advocate of ecocide law, and we thank you, given your position and the time that you have. You're a very, very busy man. Thank you for acknowledging all our meetings, all our texts, all our emails. Dr. Chilenye Nwapi, thank you very much. Apollinaire, it's always great to have you, my brother. Please keep with us. Lucian from the Environmental Lawyers Collective for Africa, Natural Justice, and Noma Sango for putting this together. Nnimmo Bassey from Nigeria. You're one of the stars of Ecocide. Every meeting I go to anywhere in Africa, once I mention that Nnimmo Bassey is part of our movement and the champion for Ecocide law, then everybody's head goes nodding in the room saying, yes, then this is very legitimate. So we thank you for being part of our network. Jojo Mehta, thank you very much for steering this movement and also attending different meetings across the world and spreading yourself and sending the message of ecocide. People say, every person I meet says your founder is very, very passionate about the subject. And I thank all the organizers, everyone at Natural Justice, everyone at Stop Ecocide International, the technical teams, and everyone who helped to put this together. I think after this, we will sit and look at perhaps another discussion on how to use the African human rights system, perhaps, and the African regional system to advocate for ecocide law. Thank you very much.